Okay, well, welcome everyone to today's webinar on GDPR Essentials for Small Businesses. I'm Alex Solo. I'm the co-founder of Sprintlaw. Just before we get into the legal content for today, to quickly introduce us to those who are not already Sprintlaw clients, Sprintlaw is an online legal team really designed to help startups and small businesses access affordable legal services. We're quite different to traditional law firms. We don't charge by the hour. Everything we do is fixed fee legal services. We operate in all the different areas of laws that your business might need help with, from helping you set up your business, get your terms and conditions in place, data and privacy, which we're obviously talking about today, intellectual property, contracts, employment law, pretty much whatever your business may need, we should be able to help with it. We have a team of lawyers who are experts in various areas of law and are able to help. We also have an optional membership. About 90% of our clients sign up to it. It's a great way to stay engaged with us. You get unlimited quick consultations with our lawyers throughout the year. There's free documents you can make. We monitor your legal health and let you know things you may not know about that you might need to do. There's an e-signatures tool in there, kind of like DocuSign, and also credits to spend on legal services throughout the year if you need them. And as of very recently, we've launched a legal AI tool, which if you haven't checked out already, is a great resource for simple questions you might have about legal matters. And also, if you've got documents, the AI can actually read them and give you some initial thoughts. So there's a free version of it where you can check out some of the features. If you haven't checked it out already, do feel free to sign up on our website. Otherwise, this is kind of what we do. We're a team of a little over 50, been around for a bit over 6 years, headquartered in Australia, hence my accent, but expanded to the UK back in 2020. And we're also active in New Zealand. We have over 7,000 clients, won lots of awards. Last year was a big year for us in the UK, and we were named most innovative firm of the year at the British Legal Awards, and also won the same award at the British Legal Technology Awards. And our vision and mission is really to transform the industry and help smaller organizations actually get good legal services. So again, hopefully, if we haven't worked with any of you already, we hope to in future, and encourage you to try us out if you have a legal problem. And if at the end of this session you are gripped by an inexplicable urge to get some help with privacy, you can reach out to our team for a free chat, and we're happy to answer some questions you may have and help you with any documents that you may need from there. So let's get into it. For today's session, we're going to be covering a bit of an introduction to the GDPR. We'll start with the basics. What is the GDPR? We'll then talk about the different concepts or different kind of characters that the law sets out in the GDPR. We'll talk about what you need to do in order to legally actually process data, and what consent requirements you may need to comply with when you're collecting that kind of information. We'll cover what rights people whose information you hold or data subjects have and how you can comply with those rights. What to do in wartime if there's a breach, a ransomware attack, or some other way in which your customers or others' personal information is breached that's in your control. Steps you can take to ensure that your suppliers are complying with the GDPR. Fees that most people should be aware of that you may need to pay each year for compliance. And then after we've covered all that, at the end, we'll have a little bit of a recap and some key takeaways and actions. As I'm going through, do feel free to use the Q&A feature. If you have questions on any of the slides, I don't mind answering questions as we go, but also happy to leave a little bit of time at the end for questions then as well. So let's begin with the basics. What is the GDPR? The GDPR is a privacy law that governs the collection, use, and storage of personal data in the UK and EU. So it came into effect in May 2018. And obviously this was before Brexit, but after Brexit, the law was kind of split into pretty much identical versions in the UK and EU. So there's really two laws, but it does cover both of the regions. And when it came into effect, it was one of the toughest privacy laws globally. And it has, since 2018, actually influenced many international regimes. California launched the CCPA in 2020. Brazil launched the LGBT in 2021, heavily influenced by the GDPR. Many countries around the world are reviewing their practices, and certainly in Australia, there's about to be a big series of reforms really modeled off what happened in the UK. So it's been an influential set of laws. There's been critiques of these laws, but in general, the additional care that organizations have to give to personal information, as a result of these laws, has certainly increased, and the concepts in here are starting to become kind of global standards in the way information is handled. And the goal of this thing is really to protect individuals' rights and make sure that organizations, particularly businesses, are handling personal information that they're going to be collecting in a responsible way. So at the kind of core level in the GDPR, there are different actors or characters that the GDPR defines. And it's important to understand these concepts because a lot of the language around data and privacy is kind of in relation to these concepts. So we have the concept of a data subject. That's an individual whose personal data is being collected, processed, or stored. So that might be the name and email address of your customers, your employee's address, anything. When we talk about personal data, anything that could be used to identify this person that you may hold. The person that it's about is the subject. So when we're talking about data subject, we're talking about the person whose personal information we're dealing with. We then have this concept of the data controller. So this is the person who went out there and collected this information and is going to be controlling kind of how it's used. And then we have the data processor. And so these are other organizations that the controller who's collected this information may be giving it to. Maybe it's the email software that you're using, or maybe it's a contractor that it's been shared with. That person is using the information of the subject in accordance with instructions given by the controller. And so for businesses in general, you're going to be a data controller. In some cases, you may also be a processor. And when you are a data controller, you're responsible for ensuring that any processes that you share the subject's personal information with, handle it in accordance with the GDPR. So just to bring that to life with an example, which may be an actual thing that happened to some people here, when you inquired through our website for help with a legal matter, we would have received name, email address, potentially your telephone number. We would collect that, store it in our Pipedrive CRM. That's a software we use to handle all of our contact information. And so in this situation, there's kind of three parties. We've got the data subject, which is you, the person inquiring. We have the data controller, which is us. You inquired through our website and we're kind of handling information. And then we've got Pipedrive, the software that we use to handle information. It's the processor. We log into Pipedrive, we can move information around, we can delete it, so we're kind of controlling how that information is used, but the actual information is stored on their servers. And so that's kind of how this stuff fits together. And so that means that we, Sprintlaw, as a controller in this scenario, are responsible for making sure, of course, that Pipedrive, this software that we're using, is handling your information in a way that complies with the GDPR. And you can see in this scenario, if you're inquiring with us, sharing information with us, and we have a terrible software supplier that doesn't comply with any standards and is out there leaking information and so on, that would not be a very responsible way to handle your personal information. And so the GDPR puts this responsibility on the person that went out there to collect it, to make sure things are handled in accordance with GDPR requirements, and also to make sure that the people that the collectors decided to share it with, often cases software vendors, also have their ducks in a row in terms of complying with the GDPR. So hopefully that helps people understand these concepts, and we'll be talking a little more about subjects, controllers, and processes, but this is kind of a good way of thinking about who they are in various situations. So if you're a controller and you're going to be processing personal information, you have to ensure that you have a lawful basis for doing so under the GDPR. So if you are going to be collecting someone's name, email address, phone number, whatever it is, before you can do anything with that information, there's got to be a reason that the GDPR accepts for you to do something with that information. And if you don't have a reason that falls into one of these 6 categories, you aren't able to do so, and you'll be in breach of the GDPR. So the first is you've gotten their consent to use their information for a purpose. So, for example, if somebody signs up to a marketing newsletter through a sign-up form, and they tick a box that says, "I'm happy to receive marketing emails from you," then they've given you permission to use their information for that purpose of sending the marketing emails. So tick, you're able to then use that information to send the marketing emails, and you have a lawful basis for doing so because they consented to do so. And we'll talk a little more about what consenting means and how you might actually do that in practice. But consenting is an extremely common way for you to have the right to use people's personal information under the GDPR. Another is a contract. If somebody makes an order with you, they decide to buy some goods or some services from you, and they sign a terms and conditions or a contract, you may obviously need to use their information to fulfill that contract. You might need to use it to share it with the courier to get their goods delivered to them. So if they've agreed to receive a service from you, and as part of doing that, you need to use their information, then that's another reason you can do so. So you may not have gotten their specific consent about how to use their information in every case, but they have signed a contract with you asking you to do something, and as part of that, you need to use it. Again, you then would have a lawful basis. And again, that's a very common reason people rely on to use people's personal information. Legal obligation, you have to because a law requires you to do so. So for example, when you're an employer processing tax information, you don't need to get consent every time you do that. You have to comply with the law. If it's a life or death situation, for example, in hospital, if there's a task of public interest, so for example, government bodies often do things with people's personal information without specific consent, and that's kind of allowed. And finally, we have this fairly broad category called legitimate interests. And and this is also relied on quite a lot. So, processing is necessary for the organization's, what the GDPR calls legitimate interests, which is a kind of broad term and not really defined, provided these are not overridden by the individual's rights. But to give you an example of what that means, if a business in kind of conducting its usual activities decides to use people's personal information for a reasonable purpose, that the client might reasonably have expected it to be used for when it was provided to them, then that's also generally okay. And a common example of that is, a client has previously worked with you, maybe they've bought goods or consumed services of your organization, and then you contact them later on about a new service that might be relevant to them. They may have not specifically consented or contracted with you, to learn about this, but it's part of the operation of your business to engage with your clients. It's kind of reasonable to expect that. And as long as the client hasn't explicitly said to you, hey, I don't want to be contacted about this, the GDPR has this kind of reasonableness category at the bottom. Now, because it's not well defined, it's not necessarily the best idea to always rely on legitimate interests, but it's generally accepted that scenarios like that are kind of okay without always getting specific consent. So that gives you a sense of when you're allowed to process people's personal information. And for those of you that are not aware of the GDPR requirements, and you may be thinking about your organizations today, I mean, chances are you may fall into one of these categories for a lot of what you do anyway. But it is worth thinking about whether, when you're collecting that information, looking at it through this lens, and is there a lawful reason that I am or a lawful basis for me to use this personal information in this way before you do anything with people's personal information. So that's kind of the opening concept, this lawful basis. Now, let's dive a bit more. I've highlighted 3 of these green because these are the most common ones where we have questions of, okay, well, I think I have consent to contact them for a marketing email, but do I actually have consent? And what does consent mean? A common question we get from customers. So what is consent under the GDPR? Well, the GDPR has a fairly detailed definition of what consent is. Consent isn't, they spoke to me on the phone once and I got the feeling that they wouldn't mind if I added them to my newsletter. That kind of consent under previous privacy regimes may have been okay, implied consent and things like that, but the GDPR says no. If you want to say that this person consented for you to use their personal information, you must first show that that consent was freely given. So they must have had a genuine choice to either say yes or no for you to use it in the way that you purport to get their consent. Second of all, it's got to be specific and informed. It has to tell them the specific purposes with which you plan to use their personal information. It cannot just be, you consent for me to use your personal information for general marketing purposes. That may be too general. What are you specifically going to use it for, and why are you going to use it, and who are you going to share it with, et cetera, et cetera. So it must explain that, and it's got to explain somewhere that they've got the right to withdraw the consent if they change their mind as well. And finally, when you obtain that consent, you need some kind of unambiguous indication. This may be an opt-in box where they take a positive action to click a button. Many times just relying on the fact that they worked with me or the fact that they kind of submitted the form, and somewhere in tiny fine print, I said that I was going to do all these things. If it's unclear whether they really knew what they were consenting to, then you may not meet this requirement of unambiguous indication. So there's quite strict requirements around consent, and this is why people will, reflect on their experiences on the internet, particularly in the last 5 years or so, as more organizations have rightly become more GDPR compliant, having to tick multiple boxes when they're submitting forms, getting more information about what's happening with the information. A lot of that is because of this consent requirement. When people want to do things with your personal information, they've really got to tell you what they're doing, and if they're relying on consent, which they often are, they got to get that consent. So just to give you a couple of examples, I've got a fairly basic one on the left and a little more nuanced one on the right. Let's say you have a guide on your website that you're giving out for free to people. Now, on the left, we say, download this guide, give me your first name and email address. And then we have a little unchecked checkbox at the bottom that says, yes, I would also like to sign up to the weekly newsletter. So this is good GDPR practice. You're collecting their information, but you're wanting to not only send them the guide, you're wanting to start sending them regular weekly newsletters. So if you want to do this, you really need to get them to freely consent for the purpose of you contacting them to send them this weekly newsletter. And you need some unambiguous indication that they actually want the weekly newsletter, because when they click that get the PDF button, we know they want the PDF, but we don't know that they necessarily want the weekly newsletter. So this is kind of why you see these unchecked tick boxes. Now, on the right side, we have a version that's similar, but not okay. It's got a pre-checked tick box. So again, a user could fill this in, click the button, thinking they're getting the guide, and they haven't taken a positive action, find themselves subscribed to a weekly newsletter, and you didn't really have the consent to send them that weekly newsletter. And the regulatory authorities in interpreting the GDPR have been pretty clear about these kind of scenarios, that the version on the right is not okay, and that's why a lot of the time you see people using these opt-in instead of pre-checked tick boxes. Yes, very important to kind of think about the way that you have your form set up. Now, you may be thinking as well, okay, well, I have seen these unchecked tick boxes, but also I have submitted forms where they just, didn't make me tick anything. They just said, proceeding confirms you agree to the privacy policy and so on. So how does that work? Well, you don't necessarily always have to have the opt-in checkbox. If the purpose that you're going to be using it for is related to why they're filling in the form, then clicking that big button on the right example here, we have get access, may be enough to be that unambiguous action. And so on the right, we have a little pop-up that says join the club, and it says subscribe to our newsletter for access to discount vouchers and product updates. So you're entering your email and you're clicking get access. So in this scenario, the person is literally trying to subscribe to the newsletter. So we don't need a second tick box to say, I would also like to subscribe to the newsletter, because that's what they're trying to do. They're trying to subscribe to the newsletter. So because you are only collecting their email for the one purpose in which they're clicking that get access button, in this case, you may not need one of those opt-in tick boxes. So the difference between this one and this one is that here we have, they're getting a guide, but they are also being opted into something else in the fine print. Whereas here, there's only one thing happening. They're signing up to a newsletter. And that's why you may be able to get away without the opt-in. So a nuanced point, but I think this is important in understanding the circumstances in which you have to do this tick box and you may be able to not do it. Of course, on the right here, it's not we may not need the tick box requirement, but it's not clear what's happening with your email address when you click that get access button. And so the user, when they submit their email, they're joining the club, but what is the club that they're joining? What's it going to be used for? Are they joining a club to get a trillion emails? Are they just going to get one message every 6 months? They don't really know. And so you haven't really ticked this box of being specific and informed, even if you have got unambiguous indication. So hopefully that gives a little bit of a sense. We've got a question through the chat. So with consent, you have to make the wording clear that the customers or subscribers are voluntary opting in. Yes, that's a reasonable way of looking at it. You basically have to be very clear. I mean, if you use a kind of like reasonableness test, when the user is filling out this form, would they expect after they click the button to receive the kind of communications that they're going to get from you? If they're suddenly subscribed to something that they reasonably wouldn't have thought they'd be subscribed to, then your form probably isn't clear enough. But if, when they fill out the form, they kind of know what they're going to get, and they've positively consented to that or taken some action, then you're probably okay. And that's a lot of how lawyers think about this when we're advising on it. Would a user filling this out be kind of informed and aware of what they were agreeing to? And I think so to kind of answer the question, the clearer the wording is, and the more voluntary the action is, the better practice it is for obtaining that consent under the GDPR. So hopefully that makes sense. And it's important to mention again, just to go back to these lawful bases, you don't always need consent. If there's another reason, like you've signed a contract with them or you're just trying to contact a previous client of yours, you may not need them to fill out a form and tick a box every time. But oftentimes when you want to conduct marketing activities or share information with third parties or do something a little more broad with people's personal information, you do need to have these forms and opt-ins. So that's why it is important to understand these consent concepts. And I guess just building on what I just said, there is this concept of soft opt-ins. And so soft opt-ins are similar to what I was just saying about certain circumstances where you want to contact a former customer of yours about some kind of marketing activity, and you haven't necessarily got them to agree to subscribe to your newsletter or whatever it is, but you've just launched a new product, you've just launched a new service. A question we often get at Sprintlaw is, well, am I able to email my customer list? I didn't have these forms with tick boxes when they first contacted me, but I just wanted to know about my service. I just want to check in with them and see how they're going. So in legal terms, you can't rely on the consent to contact them for that purpose, but you can rely on this legitimate interests, which is the kind of reasonableness test that the GDPR has. And in fact, the ICO, the UK privacy regulator, has a specific page confirming this fact that, okay, well, in some limited circumstances, the ICO is okay under the GDPR with this concept of a soft opt-in where you're contacting an existing client who bought product A before and you want to tell them about product B, C, or D. You can do it, but if you're going to do it that way, you have to give them a chance to opt out when you contact them, and it can only be really used when you're sort of selling an associated product. So that's kind of how it works. You can't necessarily sign them up to weekly newsletters all the time just because they inquired with you once. So that's I think an important distinction. Another question through the chat: for commercial forms like purchase of products online, is there guidance relating to the type of data fields to include? So look, the GDPR isn't explicit about what fields you might use in a form. It doesn't say you must use a first name field or a last name field. It doesn't specify the size of the checkbox or any of those capture requirements. It's happy for you to have some flexibility in the information that you're collecting. It does have guidance, and certainly the ICO website, which, by the way, is a great resource for examples of what's okay and what's not okay under the GDPR. The main question is kind of what we've been talking about. Are you in your form making sure you're obtaining freely given, specific and informed, unambiguous consent from the user that fills it in? And if you have a form with really big fields and tiny little fine print with pre-checked tick boxes, that's not best practice. But if you're having forms like this with unchecked tick boxes, fairly clear and specific messages, then you're likely to be compliant. So that's probably the best answer I can give. Certainly there are, if you use like WordPress website or Squarespace websites or Wix, plugins out there that have GDPR compliant forms that will have be designed in a way that makes it easier to obtain a look and feel kind of like we have on screen. but ultimately, yeah, there's not really best practice about the form structure other than what we've talked about with these examples. So we've talked about the personal information consent. Now, there's another type of consent that commonly organizations have to obtain under the GDPR, which is cookie consents. So cookies are, for those that don't know, and of course, we're not talking about the tasty baked treats here. Cookies in a digital context are small files that websites or apps, when you visit them, store on your device, your mobile phone or your laptop computer, so that they can track your activity when you're visiting their website. And oftentimes organizations want to know when someone visits their website, what pages did they visit, how long do they stay on the page. Some organizations will record what the user's doing on their site and watch them move their mouse around and see what they type in. People will want to see what buttons did they click on, what errors did they face, and whilst there may not be forms being submitted by these users, the GDPR and also the e-privacy directive, another piece of law, considers this information or this kind of tracking also to require consent. So in addition to getting consents, when you're collecting people's personal information, if you're using this analytics technology on your website or application, you also need to get consent before you start tracking people. And so people, of course, will have seen all over the internet these pop-ups that happen when you visit sites, particularly those in the UK and Europe, that look like this and say, we value privacy. We are using cookies to enhance your browsing experience and to serve you personalized ads. That's another reason the cookies exist. Do you want to accept them or reject them? And if they reject them, your site must be configured in a way to anonymize that customer, to not store the cookie and to wipe it. Pretty much any website that's using analytics, which is most people's websites these days, needs to have one of these pop-ups. And if you don't have one and you're using analytics software, you're probably breaching the law right now. So it's important to get one of these installed. There's a website called Cookie Yes. There's many of them out there. They have plugins and for a lot of websites that are pretty good starting point for GDPR compliance, and you can get a pop-up kind of like this just installed, and then tell it what cookies you have, and it has mechanisms to turn it off. So that's an easy way to get compliant with this, rather than having to make it yourself from scratch. So it's not rocket science to get it set up, but you do need to have something. And it's important to mention, this is more of a software developer thing, but there are some cookies that you might use when you're saving someone's cart, or you're processing their payment. You don't need to get consent for those sorts of things. It's more about the analytics type tools, and the law has this distinction between essential and non-essential cookies and so on. But anyway, it's a bit technical. In most cases, if you're using any kind of analytics, you're going to have these non-essential cookies, and so you're going to need this pop-up. And so if in doubt, I would get one. Now, of course, the pop-up itself should tell the user that the cookies are there and get consent. But actually, the law is very specific. There should be a cookie policy that tells the user, if they want to know, what are all the different types of cookies you're using. Are you using Google Analytics? Are you using Facebook? Like, what are all the different vendors that are going to be tracking what I do when I'm on this website? Again, some of these plugins can help you put that together. You also may want to use lawyers, for example, Sprintlaw or others to help you prepare one, because this does need to be customized a little bit to your organization. Every business will have slightly different websites and slightly different cookies, and there is this requirement that you're telling the customers what cookies you use. So it's a little bit of work to identify it, but it's usually a once-off exercise when you get your website live. So if you don't have one of these, it's one of the essentials in addition to these kind of tick box collection forms. We've talked a little bit about what you have to do before you start processing people's personal information. We've talked about, in most cases, wanting to get that consent from them before you do stuff with it. Obviously, get that cookie consent before you start tracking them. Some other scenarios where you may not have to get certain consents. Once you have people's personal information and you're processing it, these data subjects, so the people who you are, whose personal information you're dealing with, have a bunch of rights under the GDPR. And these rights, you as a person controlling their personal information, you have to comply with them. And we'll go through each of them in a moment, but to just skim through the list, it's the right to be informed, the right of access, the right of rectification, the right to be forgotten, the right to restrict processing, the right to data portability, the right to object to processing, and rights in relation to automated decision-making and profiling. So these are the rights, and here's a little table explaining what they mean and in practice what you actually need to do as an organization to make sure that you're ticking the box. So we'll start at the top, the right to be informed. Individuals whose personal information you have the right to know how their information is collected, what you're doing with it, how it's shared, and to make sure that that data is processed lawfully. So what you need to do in most cases is at minimum have a clear privacy policy on your website. And this is a document that really just describes for anyone that reads it, when they give you your personal information, what you're going to do with it. And you may say, look, we'll collect your name and email address. We'll use it, of course, to provide you services, ship you orders. We'll also use it for marketing purposes if you've consented to do so. We'll share it with our employees. We may share it with certain software vendors. We may share it in certain cases offshore. In all cases, we'll make sure that it's treated with, XYZ care. And this is everything that we're doing. And this is the type of information that we might collect about you when you provide it to us. So that's what a privacy policy says. And again, it's a legal requirement to have that listed somewhere. And so again, if you're missing one of these documents or it's not up to date, or maybe you used a dodgy online template to prepare one, it's a very important document and one of the kind of pillars of GDPR compliance. And it's really in association to principally this right to be informed so people know what you're doing with the information. And of course, we talked about cookie banners as well. They have a right to be informed about the cookies. So it's the cookie policy and the privacy policy, I think, are sort of the two key GDPR-based documents. The right of access. Individuals have the right to ask you at any time, what information do you have about me and what are you doing with it? And the GDPR calls these SARs, subject access requests. And as an organization, if someone emails you or contacts you and says, hey, I want to know what you're doing with my information, you've got to, within 1 month, be able to provide them that information. Maybe you send them a spreadsheet, maybe send them an email, but you have to say, for example, in the case of Sprintlaw, we would say, we hold your information in these systems, Pipedrive, Gmail, etc. We use it in each system for this purpose, Pipedrive to maintain, reminders to contact you, Gmail for purpose of emailing you, and this is kind of how it works. So you need to be able to do that in your organization. You should have a process for it because you only have one month to do so. And if you have a lot of different softwares you use, it can actually be a little complicated to comply with the request. There's also a requirement of the GDPR that you have a local contact. You certainly need to have an email address in your privacy policy if someone wants to contact you for these access requests. But the GDPR actually requires that they are in the UK or EU. So for anyone here who's a kind of international organization with local operations in the UK, there's services that a lot of people end up having to pay for to have a local contact. If you do have an office in the UK, you can just use obviously that address as the local contact address. But yes, there is this right of access, and people need to know who to ask when they want to exercise that right. Then we've got the right of rectification. Individuals can request that you correct inaccurate data. So, if they know that you have wrong information about them, maybe displayed on your website, they can ask you to change it. They have the right to erasure or the right to be forgotten. Similar to the subject access request, at any time, people can contact you and say, hey, I want you to delete everything that you hold about me. And in most cases, you have to be able to do that. And again, not trivial to do if you have the information in 50 different places in your email system, in 5 different softwares, in notes apps. You've got their name and address. So again, it's important to prepare for that, and we'll talk a little more about that in a moment. The right to restrict processing. So they can ask you to temporarily stop processing their information. Right to data portability. They can ask you to provide them their information, not just in like a big email messy dump, but in a specific machine readable format, such as a CSV file, an Excel file, or a JSON file. They have the right to object. Of course, anytime you contact them, you've got to include these unsubscribe buttons and make it very easy for them to opt out in all your communications. And finally, automated decision-making. If you have any software or algorithms that you're using that is making decisions about what to do, with their account and relies on their personal information, you have to be transparent about how those processes work, but only if they significantly affect their rights. So for many businesses, this may not be relevant, but if you are, for example, a business that gives out loans to individuals and you collect their information and you put it into an automated system that decides they're a high risk to lend to, and now they can't get a loan from you, that can't be a black box. You have to explain, hey, we have an algorithm that analyzes this information with these kind of weightings, and this is how it works. So there are some protections around that as well. But again, for organizations that don't really do stuff like that, may not be all that relevant. So this gives you, I think, a good flavor of much of the universe of things that you need to do to comply with the GDPR. As I said, those pillar requirements is the privacy policy and the cookie policy. And the other aspects are being ready to handle requests and being able to delete people's personal information, and also be able to manipulate it and make changes to it. And if you have that stuff in place, you're a pretty good way to a lot of the compliance stuff here, the documents, and then the processes for responding to requests. So that's kind of a good summary of GDPR compliance in what I call peacetime, when you're collecting information and using it. Now, hopefully not frequently, but very possibly your organization may one day face a data breach. And so a data breach is a breach of security where somebody gets unauthorized access to personal information that you might hold. So, you might be hacked, or it might be a ransomware attack, your customer list stolen, documents are stolen, and, a cyber thief or cyber criminal contacts you and says, hi, I have all of this personal information. I'm going to leak it on the dark web unless you pay me XYZ dollars. So that is a data breach, but it may not be that intense. You can have a data breach where maybe you've had very sensitive information, passport copies, and you lose them on a train, or you leave them in a public place. That may be a data breach because people's personal information has been left somewhere vulnerable to risk. So if one of these things occurs, the GDPR has specific requirements of what you need to do. And so again, I would encourage anyone, if this happens, to reach out to legal professionals, or if you have insurers, straight away, because you want to make sure you comply with this process and don't suffer fines. But it's also worth being aware of the kind of steps. And so, the steps are, first of all, do what you can in general to avoid this happening at all. And then if it happens, you've got to call, in the UK, the ICO, which is, as I mentioned earlier, the privacy regulator, within 72 hours. Now, you only have to inform them if this breach poses a risk to individuals' rights and freedoms. So, for example, if you accidentally forward an email with someone's name and contact to, a known partner of yours, and technically there's a data breach because you've leaked someone's name and phone number, but really it's quite unlikely that they're going to suffer any risks as a result of that sort of minor data breach. You're not necessarily required to contact the ICO. It's only if the circumstances put them at risk. So don't think you need to contact them every single time even a little data breach happens. But if there's one that puts them at risk, you got to at least notify the ICO. Now, if that risk is a very high risk, so their passwords have been leaked, or sensitive information about them has been leaked, or passport copies have been leaked, not only do you have to notify the ICO, you actually have to inform the affected individuals. And of course, for many organizations, this is a very unpleasant step. And so they want to avoid data breaches that put people at high risk, because it can be very damaging for the brand, but you do have to inform the affected individuals. Now, of course, sometimes you can just contact the subset of your customers or employees who were affected if you know who they are. Sometimes you don't know who they are, and you may have to contact everyone in order to comply with that requirement. So that's sort of the notification requirements. And then finally, you're required to document all breaches. Now, this really is all breaches, including ones that are low risk, medium risk, or high risk, whether or not you had to notify the ICO. There's a requirement that if you've made a determination internally that you didn't think it was high risk, we still need a record of the breach and the reason why you didn't think it was relevant to contact the ICO. And again, if it's found that it did pose a risk and your determination not to contact the ICO was wrong, you can suffer fines or penalties as a result. And again, determining whether you have to notify the ICO or not is not straightforward. Lawyers can help you work through that. The ICO also has a really great helpline, which many businesses use. It's free when they're not sure, and you can just call and it won't be legally binding, but they can give you a sense as to whether the type of breach that's occurred is likely to be considered a high risk or a notifiable breach. And so again, encourage people to use that if they are unfortunate enough to have the data breach. So in terms of practical steps around this stuff, like what should you do right now? We encourage everyone to make a data breach response plan. It doesn't have to be super complex, but it should at least set out, if something goes wrong, what are we going to do? What are the steps we're going to take? Who are we going to contact? So anyone can pick it up if something goes wrong, visit the plan and know who to contact, and have a mechanism for determining what the risk levels are. Of course, even better than that is avoidance. Train your employees to spot the breaches, prevent the breaches, and obviously let you know as quickly as possible if there is one. Engage cybersecurity professionals if you can to just reduce the likelihood of a breach happening. And I'd also encourage people to get cyber insurance. I mean, insurances can be expensive, but given the increasing frequency of cybercrime affecting more and more businesses, if there is a circumstance where you're subject to a ransomware attack, or there is a data breach affecting your customers, the insurances could save your business. And also in obtaining the insurance, they're pretty good at helping you take steps in order to take out the insurance to improve your cybersecurity. So a good idea to look into that if you don't have it already. And I think if you get the insurance, at least have some internal documentation and processes to be ready for these things, and obviously try and reduce your cyber risk. You're going to be in a pretty good spot for compliance with the data breaches. Sarah's asked a question: do the GDPR rules differ for a business dealing with other businesses? That's actually a great segue into the next slide, in which I was going to talk about relationships between data controllers and data processors, which is often a B2B relationship. So I'll talk about that in a second, but just to directly address your question. So businesses are not people under the GDPR. So, a business's name is not considered personal data in the same way an individual's name is. But that doesn't mean that there are not GDPR rules for B2B transactions. It's just that that they're applied a little differently. So of course, if you're dealing with individuals in other businesses, so for example, if you have the personal information of a customer who is the head of procurement or sales or whatever it is at a customer organization, that person is an individual. And the fact that the context is B2B instead of B2C doesn't matter for the GDPR. It really is all about, are you an organization holding a person's name and email address or phone number or any information that could identify them? And if so, the GDPR will apply regardless of whether it's B2B and B2C. So hopefully that gives you a bit of a flavor for how to think about the difference between B2B and B2C. But where it really comes up is in this concept of engaging as a controller with processes. So just to revisit the example I gave at the beginning, what we're talking about here is you, the organization, collecting information about an individual, may use softwares, CRM system, website systems, email systems, where you store or hold your customers or employees' personal data. And anytime you do that, you have to make sure that that software vendor or processor or person that you share it with is compliant with the GDPR. Now, that might be, as I say, a software. It might be a subcontractor. It might be a partner organization. It might be a freelancer that you've brought in. But in any case that you're sharing that personal information sort of outside the four walls of your organization, you've got to make sure that the other organization you're sharing it with is compliant with GDPR. Now, sometimes they'll be, a UK or EU organization, and then it's a little easier. But if you're sending the information to another country, maybe it's a US-based software, or maybe the supplier's in another country, you've got to actually take some additional steps under the GDPR. So the most common step you have to take is to have some form of what we call data processing agreement. And so this is a contract which basically says, you, the vendor, the software company, agree that whenever I, the controller, share personal information with you, you will comply with the GDPR. You will make sure we can export the information. You'll make sure we can forget the information. You'll make sure if someone contacts us to alter the information, we can do so. You will make it as easy as possible for us to comply with our obligations under the GDPR, and you'll take measures in your organization to also comply with the GDPR. So it's a legal requirement for you to get that document signed with any outside organizations. And again, this helps keep the end user's personal data safe, because when they share it with you and you share it with everyone else, it's on you to make sure that everyone else is complying. Now, people here may be thinking, oh, I've got a whole bunch of software vendors and I never signed a data processing agreement. Well, you may have without realizing. Most SaaS or software vendors operating in the UK and EU actually put inside their terms and conditions, if you read them carefully, a data processing agreement for you. So, for example, Pipedrive, our vendor, is based, I think, with servers. Some of their servers are at least outside UK, EU, but they have a data processing agreement in their terms and conditions. So when we signed up with them, we didn't have to get them to sign a separate document. It was included in there, and they are GDPR compliant and sort of promise all those things already. So it's not rocket science for a lot of the bigger SaaS vendors, but if you're working with a smaller vendor, or you're working with someone that doesn't commonly operate in the UK or EU, or is unfamiliar with the GDPR requirements, you just got to make sure that you get them to sign one of these agreements. You can put it inside the middle of one of your normal contracts with them. If you've just got a contractor agreement or a supply agreement with them, you can add a section called data processing schedule, or you can have it as an attachment. But somewhere in that relationship, you have to say, hey, you have to comply with the GDPR because you're going to be dealing with that customer's information. So that's really important in these kind of vendor relationships that you would have in your organization. Now, the second bullet applies if you're sending it offshore to countries that aren't on the GDPR sort of approved list. So, for example, if you're sending information to common places like the US, India, or even Australia, even though they are large organizations, large countries, it's not considered by the GDPR that the privacy regimes in those countries are strong enough, to just automatically UK and EU individuals to be comfortable that their information will be treated with the same care that it would in the UK and EU. So the GDPR requires that you also put in a specific set of clauses inside your data processing agreements with them, which are a little more intense and are very specific about the data protection standards that they have to abide by. That's extra important. And for certain countries, you really need to take that extra step of making sure, if you're sharing information there, that you have a robust data processing agreement, and sometimes including these standard clauses. And you can see, it's not obvious who's on the list. Japan, New Zealand are considered okay under the GDPR, and all you need is a simple data processing agreement. But US, India, and Australia, a lot more sophisticated data processing agreement is required. So again, important when you're sending this information to just think about this. You can always engage legal help if you're not sure, but upshot is you want to have some agreement. And then finally, an agreement's all good and well, but people may say in the contract they're complying. It's an important step to take to actually assess that they are complying, and they're not just saying that they will in the agreement. So, best practice is to conduct reviews, ask them for evidence of what their data breach protocols are, ensure that they're going to tell you when something goes wrong so you can tell your end customers, et cetera, et cetera. Just had a question. I have a branch in London and Dubai. Will it apply to Dubai as well? Not a straightforward question to answer, even though it sounds like one. So for any organization based outside the UK and EU who is dealing with the personal information of UK and EU individuals on a more than transient basis, is required to comply with the GDPR. Now, if you have a London branch, and the London branch is like a subsidiary organization set up there, and it is the entity, if you will, that is dealing with all the customers' information, it's the one that has to comply with the GDPR, not necessarily the Dubai one. But if you're set up only in Dubai and you just have operations in London, then yes, even though you're not actually set up in London, you would need to comply. So that's the first distinction. And then even if you have sort of separate entity in London that's complying with the GDPR and it's the one that deals with all your UK, EU customers. If you are transmitting information over to the Dubai entity for whatever purpose, because you have some staff there or people there, or you're processing it there, again, the Dubai entity may be a processor for the London entity. So you may need to have an agreement between the two entities with stuff like what we're talking about on this slide, a data processing agreement. So for example, Sprintlaw, we conduct most of our activities under Sprintlaw UK. In certain circumstances, our Australian staff will deal with UK personal information. We have a contract between our Australian entity and UK entity that is similar to what you're looking at on screen, a data processing agreement with SCCs, and we need to do that to be compliant with the GDPR. So the answer is, largely yes, you will have to comply, likely in some way, either through the London entity and or the Dubai entity having the privacy policy and cookie policy, and potentially if there's entity transfers, some of these data processing agreements. Moving on to some other compliance steps, we've talked a lot about what to do in peacetime, just covered what to do in the case of a breach, what to do when you're sending stuff to other third parties. Finally, we just come to a kind of administrative requirement, but one that some people aren't aware of, but basically applies to every organization in the UK. So every organization who processes personal information in any way needs to pay a data protection fee to the ICO. And this is to enable the ICO to operate and facilitate, helpful assistance in relation to the GDPR. But it costs money depending on how large you are. So £40 a year for micro organizations, £60 a year for small to medium, and $2,900 a year for larger organizations. If you haven't paid this yet, you should. You can get fined or penalized for not paying the fee. And it applies. I mean, if you're an organization that holds personal information of individuals in any way, which 99.9 organizations are, then this kind of applies to you. So again, if you haven't paid this fee yet, it would encourage you to go to the ICO website. You can do it yourself. It's fairly straightforward, and you get a certificate to say, we have paid the fee and we're compliant with the basic data protection stuff. So what are the consequences if you don't comply with the GDPR? Well, look, you can be fined by the ICO and in Europe, the European regulators as well. And the fines are pretty big. They can be up to £70.5 million or 4% of an organization's turnover, whichever is higher. Now, people often think, oh, okay, yes, there's this law, but they're going to go after the big guys only. Sadly for small businesses, the regulator is enforcing the GDPR against them. A lot of non-compliance happens from smaller businesses who don't have the resources to comply. In recent years, there's been an increased amount of penalty activities in the UK for smaller organizations. We've got 3 examples here that happened in the last few years. Tax Return Limited, a small, less than 15 employee company, got fined £200 for sending unsolicited marketing text messages. It sent tons and tons of SMSs, outbound SMSs to people it had no consent to do so for. So that they got fined a lot. Emma's Diary, it's a UK app company, less than 50 employees, fined £140,000 for reselling personal information. It did a deal with a third party to share its customer lists in exchange for commissions or whatever it is, and didn't get consent to do so, didn't get that specific consent to do so when it collected the information. So again, breaching some of the requirements we covered, £140,000. So they're not being charged $17.5 million, but they're being charged enough where it can really be business ending for these smaller organizations. And finally, DM Design Bathrooms, a medium-sized services company, was fined £160,000 for making outbound calls, unsolicited calls, without getting consent to contact those people. So these things are not abstract penalties. They do come after small businesses. How do they find out? Often one customer complains. And in the UK, individuals are getting more and more educated about their rights and are not afraid to complain when they are getting sent messages that they didn't consent to. So it is important to make sure that you're complying. All it takes is a couple of customers to complain, and you can get unlucky with one of these penalties. So just rounding things up, what do you actually need to do off the back of all that information I just provided? Well, here are, I think, 7 key steps. First of all, get that privacy policy and cookie policy. I said a couple of times that's really like the pillar requirements, very specific in the GDPR and the e-privacy directive, that whenever you're collecting information, people have the right to be informed. So you got to tell them what you're doing with it. And make sure if you are wanting to rely on consent to contact them for purposes other than why they inquired, that the forms that you have are complying with those form design things we talked about, often cases having the unchecked opt-in button. 2, make sure you pay that annual ICO fee. Like I said, it pretty much applies to everyone, and it's just go to the ICO website and pay it. 3, get ready for requests from people about their personal information. Have a contact address set out in your privacy policy for where they can go to, and then when you get emails to that address or requests from customers generally, make sure you're ready. I mean, it's non-trivial to actually delete everybody's personal information, and if you don't know where it's all held, if you've just been signing up to stuff and putting things in various places, you may not be ready. So, we at Sprintlaw maintain a personal information register where we actually have a list of systems that hold personal information, and it's quite a simple sort of spreadsheet with column A is a list of softwares, column B is what kind of information is held in it. So anytime anyone asks us to forget them, we can kind of consult the list, and we know, okay, we have to delete it from this system, this system, this system, and this system. And if they ask, what do you do with my information? Again, it's quite simple because we've put it together in a register. So you don't have to do it that way, but when we say build processes, just be ready for those requests because they do come in. Be ready for a breach. Hopefully it doesn't happen, but make sure you're ready to call the ICO, the helpline if you're not sure, for free thoughts on what you need to do. Lawyers if it's a big one, and be ready to notify them within 72 hours and make sure everyone around the organization knows they have to escalate when a breach occurs. Check those vendors. Anyone you're sharing personal information with outside the organization has to comply with the GDPR extra requirements if they're offshore, and get those contracts in place. And then the final practical steps we have: consider the cyber insurance. It's a great protection, and make sure you are conducting those ongoing cyber and privacy reviews in general to make sure that your measures are up to date. So that was all of the content I had. There's one question I've just seen here that I'll answer. If anyone wants to drop any other questions in, I'm happy to go for another couple of minutes and respond to them. So Aspa's asked, what about when you use WhatsApp on the web page? Does that count as saving the number? Indeed, it does. I mean, if you are using a sort of WhatsApp chat feature and you're collecting people's personal information, whether they just provide it to you on the chat or before the WhatsApp bubble appears, you ask them to log in or whatever it is. Yes, you need their consent to use that information. WhatsApp in its T's and C's has, I think, some stuff that covers basic uses of WhatsApp as like a support feature. But WhatsApp isn't going to be able to tell the customer exactly what you're going to do once you have their name and to contact them. So yeah, if you're collecting, getting information that way, you have to think about these requirements. If you're going to use it to do something they wouldn't expect, you've got to get explicit consent. If you're going to use it sort of as expected, you may not need to get extra consents, but you've got to be careful what you do with that information if you collect it via WhatsApp without a consent. Fantastic. I hope people found this presentation useful. We're going to do them every couple of months for the rest of this year. Encourage everyone to sign up to the Sprintlaw platform. Even if you just want to take out a free membership, you can track when these webinars are coming up. And if people have feedback, would love to hear it. But I hope you have found this useful and educational. If you need any help with privacy stuff, do reach out to our team. Otherwise, it's been my pleasure, and I look forward to presenting again to you all some other time. Thanks so much.